Okay, we're almost ready. So today, today I wanted to talk about listing agreements, and we've got a article going out this weekend. And this weekend article is going to talk about listing agreements specifically with Nabor, and what they say, what's important to know about them, a nice review of it. But then also, how do you handle your client over your listing period? What are your obligations? What's the client's obligations? And how do you protect yourself from things souring? Because that's kind of a natural occurrence, is that these long-term relationships are really very difficult to stay on top of. You find that, the client starts, they start questioning you more as time goes on. They might even see some of our flaws, heaven forbid. In fact, I see that a lot with myself, where I can usually make a really good impression with a client over a 30 or 60-day closing. But if it's a 6 or 12-month scenario, like say it's litigation or something like that, it is hard to maintain that level of respect that your client has of you. They hire you initially because they're impressed. They think that you've got everything it takes to be great and to get the property sold quickly. But if it takes 6 months, they start seeing little hairline fractures. And so today I wanted to talk about that. I want to talk about that in relation to the listing agreement, specifically with Nabor. We can also look at the FAR one or the FAR listing agreement. And just kind of gives a little heads up on how I look at that, and then how I might be able to help you or your client in regards to your listing agreements. So let's start with strategy. I think strategy is kind of the most important part in this case, and I would love for you guys to give me some feedback on how you've handled it. You can raise your hand, you can talk in the chat feature. But to me, there are going to be a lot of periods where there is no feedback. There's no update, there aren't showings, or there's just no good feedback that we need to share. And yet you don't want to say nothing. So what I was taught a long time ago was set up expectations so that your client's not wondering what's happening next or what's happening over there. And in my office, we struggle with this ourselves, so we're not immune to this at all. It's funny, when we get a contract in, you get a barrage of communication from the realtors and the title company and maybe even the lender, the inspector, insurance. You get all that in the first week, and it's totally overwhelming. And most of the clients, they're like, all right, I don't even know what to do with this. But then in the second week, all that starts to die down, and it's kind of this like 100% go and 0% stop, or 100% stop. And so we struggle with the same thing, and we look for little touch points during the closing period. So if you have a 30-day closing, that first week we get maybe it takes a couple days for the contract to come in. You're trying to make sure that the inspection goes okay, but you send us the contract. Within 24, maybe 48 hours, we are going to call your client on the phone, introduce ourselves, and explain that they are going to be receiving an email from us with next steps. Here's what you'll need to do next. And I think it's such a great touch. And my dad actually implemented that a long time ago, and we continue to do it. And so I'm really grateful that my staff has bought into that, because it makes it more personal. So that phone call, very, very important. That's how we get started. And then we followed up with an email. And the email has a letter in there that says, thank you for allowing us to handle your closing. Here's what we would like for you to do for us. And we have a link. And if you haven't used our office before, if you weren't aware of this, we ask our seller and our buyer to fill out an information form online. In fact, I could probably take this opportunity to share it with you. Let's see if I can pull something up. So this is our current website. I believe I'm sharing the right one. Yeah. So this is our current website. Just so you know, we are having it redone, which I'm very excited about. It's taken all year to do. But when we have a new closing come in, we'll send them to a hidden site, a hidden page on our site. And it's this buyer questionnaire or seller questionnaire. It introduces who the closer is. And we ask for certain information be imported. So let's say our closing is going to be next year and it's cash and we want to sign electronically. And then it just keeps asking for questions. And so this is something we want our buyer to do. We want to know as much as we can about them. And so they can spend the next couple of days, the weekend, even into the next week filling this out. And then the next week, we are waiting for things to come back. We're waiting for, the title to come in, for the lender to send a title order, maybe, but there's not much else. And we've already sent the buyer everything, we've sent the seller everything. There's usually not much in that second week, unless we're being, asked to close it in the second week. So that's where we struggle. And there's this gap where we say, all right, how do I contact this client when I have no update? And so what we try and set up is expectations. We say, look, you're going to send this out, and then there might be a moment, there might be a week or so where you don't hear from us. Don't hesitate to call us if you have questions, but we will then reach back to you when we start, scheduling your closing. That's kind of the next thing, especially if you're a buyer. Let's schedule a closing. What are you going to do? And what questions can we answer for you? And hey, now that we have title back, we have this issue or that item. And so as long as everything is operating the way it should, your client will hear from us every week. And that it solves a lot of anxieties with our clients. We tend to have fewer clients call anxious that they haven't heard from us in a couple of weeks. That doesn't happen if I have anything to do with it. And that's what I would ask you guys to do as well, is that you set expectations where if you have good news, bad news, or no news, you will be calling that person on Wednesday. And that's kind of the nice thing about this class, is that every Wednesday at 11 a.m., I intend to host this class, whether I have something to say or not. Hopefully I can talk. Hopefully we'll have an opportunity to go through things. And your clients need that. My clients need that. My expectations for you is that you'll need that from me as well. So that's the key. And what it does is it prevents your client from going off the deep end. It prevents them from going, saying, well, if Ashley can't get this, I'll go find it myself, or, maybe my neighbor is making the right offer and I never should have listened to so-and-so. But if instead it's like, well, I'll talk to him on Wednesday. You can already see it has a better effect a lot of times. But if you haven't seen the buyer information sheet or seller information sheets, this is what that looks like. It's really great. We are moving to a secure portal on this, so it's going to be a lot more secure going forward. We also have this same thing for you guys. So these are our commission instructions. So no longer do you have to fill something out and mail it in, or even email it to us. You could just go on and fill this out, and it's just going to ask you for the pertinent details. What is the commission? Are you offering credits or something along those lines? What is the split? Things like that. So hopefully you'll find that to be very helpful. And then let me stop that. All right. So now I think the key is, if that's the overall strategy, communicate, communicate, communicate. It makes sense. It's a sales tactic. That's great. But where is that derived from? It's derived from the contract. It's derived from the listing agreement. So let's look at the listing agreement. And I want to point out several things that hopefully will be helpful to you. See if I can pull up the right forms here. So I started with just the NABOR contract, but a lot of this is also in the FAR bar. Maybe not everything, but a lot of it is. So the key is, which contract are you having your client sign? That is so important. I'll give you a little story as to something that I found recently. We had an estate. The estate, the prior owner had passed away, who is now in the estate, and they were going through probate. And the question was, well, who needs to sign? And there ended up being four owners of the property. And the sellers, they had a family friend who was an attorney who said, look, Bob is the one that signs everything. Just let him sign. Don't, it's too much work. It's such a pain to have all four owners sign. Whatever Bob says, that's what we'll do. they're probably right that practically speaking that will work, but when you ask an attorney a legal question, they're going to give you a legal answer. And so that's what my job is. And in that scenario, it would be a disaster waiting to happen if you didn't have everyone on the contract sign. Anyone that owns the property or has an interest in the property needs to sign the listing agreement. And it's not just, do you trust them? It's the fact that you're going to take that and you're going to put it on the market and you're going to offer to share in commission with another agent. And if your seller backs out, or if one of the heirs backs out, someone that you're not as familiar with, and blows up the whole deal, you could be in a lot of trouble because you offered to share commission on a listing agreement that you didn't have firmed up, that was, non-exclusive, or that was voidable, or that was void on its face. So this is everything, in my opinion, because this is where you lock in your ability to earn a living and to share in commissions with another person who's trying to earn a living. Without this, none of the other stuff works. My mindset for all of these classes has been threefold. Go under contract, protect your client, and close. This is part of the first and the second and the third. This is very important. It's just as important as the actual sales contract, because this locks in your right to list the property, to earn a commission, and then therefore share it, list it, do all of those things. So this one I picked, this is obviously the most common. You're going to have the exclusive listing agreement for either NABOR or FAR/BAR or FAR, and it's the exclusive right and authority to sell the real property hereafter, including any personal property, trees, shrubbery, landscaping. They have a commencement date, they have a terminating date. Interestingly, if you don't put anything, it's 270 days, which is, I believe that's 9 months. You describe the property. This is very easy. The legal description is on here. I assume all of you know that you can get the legal description from the tax assessor website. You can get the short legal. That's usually sufficient, especially if it matches the property address and the tax parcel ID number. That is very key. And I will warn you, if the seller is a developer or anything along those lines, this part's particularly interesting because we have to know what we're selling. We're not just selling the prior sale. We might be selling just one lot or a portion thereof. So that's a very key piece. Listing price, that's what you're holding your seller to. It's very important. So if it's $1 million sale price, you put million in there, because if you get a $1 million offer, the seller is now obligated to pay you a commission. So the price is incredibly important for you. And being able to enforce this agreement. Let's look at the broker obligation. This is your business. This is everything as to what you do. And it's really light. It's vague, in another word. So let's look at it. Consideration of granting this exclusive right and authority to sell. The broker agrees as follows. A, to become informed about the property. I think that's a pretty low bar. It's hard to define exactly what that would encompass, but your job is not just to put it on MLS and take pictures. You're supposed to inform yourself about the property. Is it in a flood zone? What kind of insurance would be needed? Is there a mandatory membership to the social club, or is it voluntary? What's the cost of that? These are very important things. And I believe that if you were just mailing it in, doing it remotely, you could be in violation of the very first thing in your listing agreement. Now, most of you will do it this way, I have no doubt, but it's important to be reminded as to what your job is. I have to know the property. This is what I'm selling. I have to be an expert on this property. I have to have looked at the survey, looked at the elevation certificate. Is there a radon system or not? Which windows were upgraded? Which ones still, are the old style? Those sorts of things. B, to make earnest and continuing effort to sell the property. However, this listing contract does not guarantee that such efforts result in a sale of the property, and seller affirms that no such sale assurances or guarantees have been made or implied. there's a lot of legalese there, but to make an earnest and continuing effort to sell the property. It cannot be go, 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 and then take your foot off the gas for a year, because you could be actually held in default. If you're not contacting your client regularly, this could be a problem. C, to promote the property as broker deems appropriate. So that allows the broker, the agent, to determine how to market the property. Hopefully you're getting input from your seller, but you're the reason, you're the driver. You're the one who's supposed to come up with the ideas and execute on them. D, to keep seller informed as to broker's efforts. There is a case in the state of Florida where the judge determined that the broker had failed under this requirement of keeping their seller informed. Now, it was a pretty bad facts and circumstances. I believe the seller hadn't talked with the broker for over 2.5 years. That's pretty extreme, but it also, I don't think it has to be that extreme to be in violation of this duty, to keep seller informed as to broker's efforts. I think if you're in court saying, look, I didn't wait 2.5 years, I think you've already lost. It needs to be a weekly, bi-weekly, monthly type thing where you have a standing appointment to talk with your client on that time frame, whether you have an update or not. To take reasonable precautions to prevent damage in the process of showing the property. There's stories of where people have fallen and hurt themselves, or where personal property has been stolen during the listing. So your job is to take reasonable precautions. Basically, you have to warn people if there's something that you don't, that they need to be worried of. Like if there's some pavers that have come up and they're in the process of repairing them, warn them about it. Put a little sign, make it so that it's harder to actually access that portion. To distribute such information related to the property as broker deems appropriate to other real estate brokers, and to invite cooperating brokers in procuring a buyer for the property. In the event a buyer is procured by another broker, broker will assist the cooperating broker to complete the sale and shall compensate the said broker as provided in this listing contract. Get it sold. I think that's what that says. And then we talk about, well, how is the broker going to do this? Enter it into MLS within 5 days of the commencement date, or shall not enter this into the MLS. Now, here's a scenario. You might have a particular deal where it's going through probate, and they're not going to be able to sell it until probate is finished. So in that scenario, you may choose number 2, G2, shall not enter this listing of the property into MLS. You want the listing, you want to keep it off market, but then maybe we'll put in language down below under special terms and conditions or other terms and conditions. Upon probate being finalized, broker shall enter it into MLS. That's what that would be for. There are a lot of scenarios I've heard recently, especially with the storm, that you might actually impart this, and you would want to reach out to your broker and get their feedback on that. H, broker shall or shall not disclose the existence of other offers. That should be something that you drive that conversation. You should know what you want in that case. Internet options, it's kind of funny that they haven't changed this language, internet options. It's kind of a old school wording. Of course, you're going to put it into MLS, or that's the initial impression. If your seller is going to ask for something else, reach out to us, because we see a lot of times where a seller doesn't want it in MLS, but they don't truly understand the benefits of it. So I would say that's a weird scenario where they're not wanting it in MLS. Broker relationship, I think that is pretty self-explanatory. Let's look at seller obligations, number 4. All right, this is what the seller has to do to comply with their contract with you. Number 1, to refer immediately to broker all inquiries about the property, whether those inquiries are from other brokers or any other persons or entities. That's a key thing. If the seller is getting inquiries from the neighbor, they have to tell you about it. I think it helps in your selling of the property to know that the neighbor is very interested. That's their agreement. They're agreeing to list it with you, even if you end up selling it to the neighbor. B, to provide broker access to any improvements on the property. for purpose of inspection or presentation to prospective purchasers, they have to make it available. If they sign the listing agreement, put in MLS, and then don't let you on the property, they're in default. They're opening themselves up. So C, to inspect the property from time to time prior to any scheduled inspections, to delete and remove any safety hazards. They're supposed to be good sellers. They're supposed to be your partner on this. D, to comply with applicable statutory disclosure requirements. So that's where you get to say, you have to disclose this thing. It's Florida law. Otherwise, I'm going to have to on your behalf. That's a good place to remind them of that. I don't know if someone may have raised their hand. If you still want to talk, I would love your feedback. That'd be awesome. But let's keep going on this one. So to provide broker with all relevant information related to the property. You know what I like about this, and I don't have to go through each one of these. I think there's other things we can look at. The thing I really love about this is that you could use this in your talking points with the seller, because what it does is it drives the conversation. It says, all right, well, here's A, you gotta open it up for me. Or what was A again? To refer immediately. Have you talked with the neighbor? Is your sister still interested? What has been the feeling on this? Who do you want to sell it to? What are you thinking? That sort of thing could be very important that you may not come up with otherwise. So I think the seller obligations are pretty straightforward. And then the key is, well, what happens if the broker doesn't do that or the seller doesn't do their obligations? And so we would look at let's look at the default language. And these are the seller sales contract obligations. We'll have to look at that a little later. Seller disclosures. All right, Angela has a question. All right, Angela, you'll have to unmute yourself if you'd like. There you go. Go ahead.
Hey, Christian, I just wanted to tell you that we can see your email and not the contract.
No. Okay, hold on.
Yeah.
Oh yeah, it did change. That's weird.
Yeah.
Did I get any good emails, Angela?
There you go. I wasn't looking.
Okay, thank you. I appreciate it.
Yep, no problem.
All right, so sorry about that. This is the listing agreement. Let's go down to default. So anytime I review a contract, I want to know, all right, what do I have to do? And if I don't do it, what happens? And that's what default would be, that second part. If the transaction is not closed because of the refusal, failure, or inability of seller to perform, or seller fails or refuses to enter into contract with a ready, willing, and able buyer of the property, seller shall pay the compensation to broker in full upon demand. That is powerful. So if the seller does not make the property available to prospective buyers as they are required above in the listing agreement, that's a problem. Because if it really got worse, if that relationship deteriorated so much that they're just kicking you out, they signed this agreement and that would be their default language. I would hope that it wouldn't resolve in a lawsuit or something along those lines. But I have seen it. I had one this year where the seller refused to accept a full price offer, thought maybe they could get a little bit more. And then when they couldn't and the market turned, the broker actually had an obligation, or they didn't have an obligation, but they had the right to put a lien on the property, and they did. The relationship with the seller had frayed so much because the house had been on the market and the seller was being very difficult, and they had brought and denied a full price offer, that the broker's like, look, I'm not going to make you happy. I've performed. I've done my job. We are going to go after you for the full commission. And they did. That's not going to be the case, hopefully, with any of your clients, but there's a lot of power in that default clause. Let's keep looking. In such event, this listing contract shall not be terminated, but shall continue in full force and effect. If seller fails or refuses to pay broker's compensation after demand, seller hereby grants to broker the right to place a lien on the property, which right shall survive termination of this listing agreement, and any such lien can be foreclosed in the same manner as a mortgage on real property. Obviously, this would require you going through a court to do that, and I don't know if a court has granted that before, but they're trying to give you all the power in the world to enforce this clause. If deposits, this part is very interesting. I love this, and it does happen. If deposits are retained by seller, 50% thereof, but not exceeding the full amount of the compensation to broker, shall be paid to broker as full consideration for broker services, including costs expended by broker, and the balance shall be paid to seller. So what does that mean? If you have a sales contract that the buyer defaults on and the buyer loses their deposit, up to 50% of that deposit is supposed to go to the broker, supposed to go to you, the listing agent. Not many people take advantage of that, but I think you should. And here's why. Very few brokers actually collect on this clause. It does happen. I know of two just in the last couple of years where the broker did receive a portion of the deposit when the deal fell apart at the last second. But more likely, the nice thing is if you bring this up, let's say a buyer defaults, seller's going to get the deposit. It's a great opportunity to talk to the seller and say, look, my broker has the right to retain 50% of this. That's how the contract works. But I'm not going to be greedy. What I would like instead is just let's extend our listing agreement, because what I want is to get your property sold. I'm not here to double down on my commissions. Honestly, I see it both ways, and you have to be the judge as to what you want to go after. I've seen it done very tactfully, where the seller's like, oh, well, that's the agreement. Broker gets 50% and I get the other 50%, then let's do it. I do think that deposits are high enough that the seller still is pretty protected in that scenario. But it's something to know. You should always use that to your advantage to create some sort of benefit, to even just tell your seller, hey, I'm giving this up. That's another value add of what I provide. So don't let that go idly. Make sure that you talk to your seller about that in that event, and at least get some sort of 6-month extension in lieu of taking that deposit. If you're going to change anything in this contract, that's when you'll reach out to us. I think changing things on these contracts is bound to happen. I think that you're going to have a lot of, say attorneys or developers or real estate agents from other parts of the country that are coming down here, and they'll mark it up, things that aren't relevant, things that they don't like or want to change. Just reach out to us. One of the things that we offer here is broker services. We usually handle your closing, but when it turns and I need to help you personally, that's what we're here for. So if you need me to look at a listing agreement, look at a buyer brokerage agreement, that's something I would love to do. I'd be honored to help you with that. Let's go back. Before we close this up, the other key on this was the seller sales contract obligation. And let me see if I can share the correct screen. Angela will tell me if I didn't. All right, I think we did. All right. In the event broker secures a buyer for the property, and unless the sales contract provides otherwise, seller agrees to the following. A, to provide and pay for the following when applicable. This is derived directly from the NABOR sales contract. And so they're intertwined. And so it is a good opportunity to say, look here, because a lot of times people are wanting to know, what's your seller net? What am I going to net? And so you can actually use this to determine what cost might a seller incur at closing. And then I'll show you on my website where you can actually get a seller net sheet directly. It's really kind of a sharp thing, but they're going to pay for transfer taxes on the deed. In Lee County and Charlotte County, they'll pay for the title insurance. In Collier County, the buyer pays for it. They'll pay commissions. They'll pay any attorney's fees to draft documents, things of that nature. But this is the big one. Other than commissions, documentary stamp tax on the deed. Here's a little question for you guys. Let's wonder if I can do a poll. I'm going to create a poll right now. And I want you guys to answer. Let's see if this could be easy. All right, here's the question. How much is the transfer tax on the deed payable by seller typically? All right, so choice 1 is going to be $5.50 per thousand. Choice 2 be $7 per thousand. Choice 3, buyer pays. Trick question. All right, poll has been added. Let's see if I can get you guys to vote on it. Launch. All right, go ahead and join. I want to see how many people can get this one right. And don't cheat. All right, so while people are voting on that one, let's just go back to the listing agreement really quick. They have to convey marketable title by general special warranty deed, free and clear of all liens and encumbrances, except those items which buyer agrees to assume. You know what that means? They can't be in the middle of a lawsuit. They can't be in the middle of a divorce. They can't have a big, foreclosure action that they can't get out from, or the probate's not done yet. They have to be ready to close. And that's an obligation that the seller has. C, to deliver possession and occupy the property on the closing date. And then prorate the following, that's another cost and expense. And then E, to grant the buyer at closing a credit equivalent to the amount of any security deposit, other tenant deposits, and prepaid rent. So if there's a rental on the property. All right, let's see if we've got the buyer poll. Let's see if we can share this. Screen 1. All right, here's our buyer poll. We've got someone that says, a couple of people that said that it's a trick question that the buyer pays. It actually is $7 per thousand. All right, so here's how it works. This is document stamps on the deed is one of the seller's biggest costs. It is $7 per thousand. So on $1 million sale, the seller is obligating themselves to paying $7,000 in transfer taxes. Now, separately, the buyer, let's say it's in Collier County, the buyer is obligating themselves to pay for title insurance. Title insurance on $1 million deal is about $5,000. So, and then the buyer's going to have additional fees on top of that. They might have a transfer fee on the HOA. They're going to have insurance. They're going to have, they might have to pay for taxes. Seller might have to pay for taxes. If the buyer's getting a loan, they're going to pay for transfer taxes on the loan. They're going to pay tangible taxes on the loan. So I say all that to say this is kind of fair. Seller pays transfer tax, $7 per thousand. Buyer pays owner's title insurance. Similar, sometimes it's a little cheaper. But overall, the purpose of this is to split the cost between buyer and seller. Now that changes in different counties. And if you're using a FAR bar contract and you're, in any county, you will see if I can share the results. In different counties, you'll see, or in FAR bar contract, you'll see where the buyer and seller can choose who pays for title insurance. But the purpose is to make it even, to make it somewhat straightforward. So I think NABOR got it right in that case. And that's how I explain it to buyers and sellers, because otherwise they get very upset and say, why am I paying for transfer tax on the deed? It's the buyer's house. And I think that's an important thing just to show that it is kind of fair. It's well-rounded in that sense. All right, so here's the last part of it. If the seller and the broker, the listing agent, just start to disagree and they want to terminate, couple of options. Number one, there's termination of listing agreement or listing contract. You fill it out. In this case, it's a mutual termination. That means all the rights and responsibilities shall expire and it's over. They do not have a unilateral termination form under NABOR, not that I'm aware of. But that's the other option. And in my opinion, is probably a little bit more likely. So I'll give you the two scenarios. Scenario one, buyer and seller, or buyer and listing agent say, look, this isn't working. I had, maybe the listing agent has a business conflict or something else that's going on. And they say, look, it's just time, we're gonna terminate this and I'll let you hire someone else. In that case, the mutual termination makes a ton of sense. Both parties will sign it. Sometimes there may even be a fee that is paid in regards to getting that mutual termination. Because as you know, the compensation, the commission is owed if they can bring a client, if they can bring a buyer to the party. And so they, if the seller says, alternatively, the seller says, hey, I really do want to sell it to my neighbor. We've been on the market for a little bit. Let's go to the neighbor and let's sell it to him. But I don't want to pay you a commission because I knew this neighbor beforehand. Well, he's got to buy you out. That money is owed. That commission would be owed if he or she were to sell it to the neighbor during your listing period. The seller cannot terminate your listing unilaterally. They would have to pay you some sort of exit fee, mutual termination fee. Maybe it's $10,000, maybe it's $50,000, whatever the number is. But I've negotiated a lot of those in the past. They're very normal. They happen all the time. So if something goes sour and the seller wants to sell to someone else, you have rights, and you don't have to sign a mutual agreement unless you're getting compensated. That being said, sometimes it's a good business decision just to let the person go. If you know they're going to just fight, and that you're pulling your hair out, I think it does make sense at times to be the bigger person, sign the mutual and move on. Don't let this drag you down. It's a good reminder that even if we do get a listing agreement, sometimes for business purposes, we have to walk away from it. You can't, you don't want to just assume that the closing will happen just because you have a signed agreement. So without much further ado, I think it makes sense to end on that point. And I love that you guys participated. It means that you're paying attention, which I love. I think you got it right. It's $7 per thousand on the deed. Separately, buyer, if they get a mortgage, they're going to pay transfer tax and intangible tax on the mortgage, which is $5.50 per thousand in that case. But we'll end there. Thank you. If you guys need me, feel free to reach out. Happy to do a closing for you or just answer some questions. Just let me know. But thank you. And I'll see you next week, which will probably be our last class before the new year. And then we'll start up again.